Okay, we are live. I'm attorney Vince Davis, and this is The Secret: How to Fight CPS and Win. And I'm joined by my two co-hosts, Mr. Darren Guai, all the way from where are you from? Oh, Maine.
Maine, way up north.
How are things?
Way up in the northern hemisphere here.
How are things in Maine, Mr. Guai?
Well, I'm going to tell you right now that it is fall. It's definitely fall. I'm sorry, my camera got hit here, and I'm trying to adjust myself. But yeah, we're definitely got fall up here in Maine, and it's coming with a vengeance. So be prepared, California. I don't know what you get for fall, but it's happening.
And we have our other co-host, Miss Georgette Truan, all the way from sunny California. How are you, Miss G?
I'm good, thank you.
Good. I see we have a special guest tonight, Miss Cheryl Cohn. Miss Cohn, how are you?
I'm about to snap. Yeah.
Where are you calling from?
Florida.
Oh, what part?
The Panhandle, the northwestern part.
Did you get that hurricane a couple days ago?
No, that was to the east of us, but yeah, same ocean.
Okay. So what's going on with you and CPS in Florida?
Okay. I told you guys last time that my trial was coming up, so we did that. It took the judge approximately 2 weeks, maybe, to make her decision, and it took my lawyer approximately 2 more weeks after that to let me know what that decision was. So she like way late on everything. I just foster mom knew before I did. She severed my rights. So I told my attorney that I want to appeal it. I don't know if she's even filed that yet. I got no idea.
Well, you should
And
verify.
so,
You should verify that she filed it.
yep, I called her, and she should be filing it like any day now to make the deadline. I think it was 30 days they gave me to appeal it. I talked to her like last week, and she said that she hasn't done it yet, but she will. So that's the last I heard. And I've been working, so I haven't been able to call her, but it's I don't know how to feel about it. I don't know what to do next.
Well, you have to appeal.
I know that. I'm sorry?
You have to appeal. That's what you have to do.
Okay, so when should I sue them?
Well, that depends upon what type of case you have. You know, sometimes I talk to people and they should sue immediately. Sometimes I talk to people and they should never sue. And then sometimes I talk to people, it's like right in the middle. It just depends. What did
they violated my civil rights?
Okay, well that's a very broad
and
statement.
They're still doing it.
How do you think they violated your civil rights?
By lying under oath that I committed a crime that I didn't, so she could remove my kids. That was the CPI. Haven't heard or talked to her since. Keeping my children from me for 3 months. I didn't know nothing about what was going on. Then separating my children, they violated their rights. As far as the laws in Florida go, that's like a last resort, and they're god awful. They've done nothing for me. They've done nothing to help me complete my case plan. I mean, I did not complete my case plan. If I'm guilty of anything, it's that. However, I did not know I didn't have to have a case plan. I was informed that if I didn't sign the case plan, I'd never see my kids again. Threatened, really, is how I feel. That's a very threatening statement. The foster mom who has volunteered to adopt my kids, who's not my family, not even in relation to my children, but to my ex, she's now cut off all contact because I voiced my concern about my children calling me by my name and her mommy. I didn't like that. I mean, I went to see my kids again, and I had a ride. My best friend took me. I had money. I was paying for the whole trip, and she had something to do the next day with her kids, and um, I had a bunch of stuff for my kids, like clothes and shoes and stuff for school, and I mean, just a bunch of stuff, like a whole car full of it. And they got a couple of toys because that's all I carried into the McDonald's where we visited. I wasn't going to carry all that, luggage in or whatever. So I left that at the hotel room, and I asked her if I can meet up with her like in the morning before they go out of town to whatever game that they had to go play that day. And she said, I just can't do 2 day in a row visits. And I'm like, what what is that? I mean, she promised me she wouldn't keep my kids from me. She promised me. And she's doing just that. So I told her about that, how I felt about that. And she didn't like that. So she's cut off all contact and told me I had to call the caseworker, which is not my caseworker currently because the case was closed, I think, when they TPR'd me. Right? I don't have a caseworker.
Well,
So,
once you're TPR'd, the case for you, the case is closed. It's
right,
still officially open, but you don't have any more rights or anything. Now, one of the
right.
things,
Well,
if
the
you're in
judge said I could see my kids and I could talk to them on the phone and I can see them. I don't know how I can have both, no rights and be able to see them. I mean, people are just like scratching their heads going, that's not how it goes usually. But everyone in the courtroom agreed that it would be more traumatizing for my children and detrimental to their mental health and all of that to cut off all ties. Well, the foster is now doing that. I haven't spoken to my kids in 2 weeks and I'm about to snap. That's kind of what keeps me going is being able to see their cute little faces and I don't know what to do about it.
Nicole, did I speak to you before?
Cheryl, and yes, yes,
I'm
I've
sorry.
been on your
I
guys' show
apologize,
twice.
Cheryl. Yes. Yeah, I remember your face. I'm so sorry. I made a mistake with your name.
It's okay.
Do you remember on the show when I told you that the foster parent will never be your friend? Do you remember when I said that? And I said to watch out from her, but you thought that she
Yep,
was on your side.
yep, I did.
Yeah. So I'm not trying to be right, but I was trying to make a point. They will never be
Yeah,
on your side.
point
Remember,
took.
people come in your life to pretend. That's it, to pretend. Then their true colors come out after you lost your parental rights. But
Yeah,
before then, they were cool. Cool. They were cool as can be. So that's my point to everyone out there who thinks that the foster parents are your friends. They're gonna do everything possible to keep a relationship with you and your kids. That's not gonna happen in any way. So please learn from other people's mistakes and don't toy with your children's lives because honestly, at the end of the day, if you have to sell everything on your back to get your kids back, do it. Because there is no such thing as this and that and excuses and this. It does it no. And all the family members out there, wake up. Don't turn against the parents because that's when they need you the most. But what the social worker wants you to do is to turn against the parents, the father and the mother, whether you're paternal or maternal grandparents, and so they can have no like no resources, like nothing. Nothing is backing them up. They're literally alone. And they don't want you to support them mentally or financially. And that's why they
yeah,
separate you from each family member in your home. And that's why you find yourself alone, completely alone, facing this demonic entity. So I'm telling everyone out there, what I've been telling you guys is to wake you guys up because my main goal is to get your children back. I don't care about any other drama. I don't care about, baby mama, daddy, baby daddy, whatever they call them. I don't care about all that. Just get your kids back and focus on that. Don't focus on getting the social workers. Don't focus on stupid crap. It's not going to help you. It's not going to help you get your kids back, for the love
Oh,
of
I
God.
know that. I'm trying to make change. I'm trying to do my part as an American citizen for other people. I already know that. I mean, I come to this part of this whole thing, and I'm not going to stop fighting until I can't fight no more. I will appeal every decision until there's no more appeals left, if I have to. I'm not giving up on my kids, but
But
I
Cheryl,
want to sue them so
but
it,
Cheryl,
people
Cheryl,
will be aware,
right.
you know.
I understand you want to sue them, and I get your justification for that. However, right now, you need to ask the right questions for Attorney Davis so he can address the issue properly. And you need to talk less and listen more, because he
Okay.
was trying to talk to you earlier. And I know you're anxious, because we all, as mothers or parents in general, we become anxious when we lose our children. However, this man is here to help you. So listen more and talk less. Okay?
Yes.
Thank you.
Ms. Cohn, do you have any questions you want to ask me?
Um, yeah, ma'am, I really pretty much asked what can I do, because my attorney, she's court appointed, so she's the one who told me I needed to sign that case plan or I wouldn't see my kids again. And she's stating that now that she never said that, but she did. Um, and I don't know how to prove that. It was just verbal between her and I. It's my word against hers. Um, so I guess I need to know what I can do. What steps can I take, even if I have to fight pro se, because I can't afford an attorney. I have contacted legal aid. Um, they seemed very interested in my case, but I haven't heard anything from them.
Legal Aid Foundation are funded. It's not. Legal Aid Foundation is all connected together. Um, Cheryl, they're all connected
Yeah.
together. So they're not going to help you. They just want to know what you have to say, so they can report what you're saying.
Oh,
So
great.
I'm just saying, they all have connection. That's why they're not going to help you. They're not. So I remember telling you guys about Oasis funding. Please, there's one potential client that applied and just waiting to hear from them. So please apply for Oasis funding. Momentum funding, do not be too, you know, don't think it's going to help you, because they only pick and chooses which states they want to fund. Like, they don't fund Arizona, they don't fund Las Vegas, they don't fund Chicago, they don't fund Illinois. Like, there's only a few states that they will fund. And the
Okay.
reason for that is because they know that these states are targeted more. Okay. So, with that being said, I found Oasis funding. They fund from $500 up to $100,000.
Okay.
Please. So go ahead and choose that.
Okay.
Do your due diligence. It's Oasis, spelled like Oasis Park, Oasis funding, and
Okay.
call them immediately
Okay.
and
Okay.
see
Thank you.
what they can do to fund you. Okay.
Yeah. Thank you.
You're welcome.
Ms. Cohn, do you have any questions for me?
I think Miss G just answered them.
Okay.
Yeah,
I'm
I
sorry.
was just like
I
stuck.
didn't
I
mean
didn't
to.
know what I could do, like if there was any hope
I'll
at
give
this
you
point.
I'll give you one tip, and that tip is to go to court and make sure that your notice of appeal is filed timely.
Okay. Can I file that if my lawyer fails? I
You
don't know. I know
can,
it's like tomorrow, if at the latest.
but I don't know if you'll fill it out the right way. So you might want to talk to your lawyer, get it filled out, and tell him that you'll take it down and, file it. You just
Okay.
need him to review it or her to review it.
Okay.
Okay?
Yeah. Will I still be dealing with the other side, like the DCF worker and their lawyer
Probably
in
not.
that court? Oh, thank
Probably
God.
not unless you win your appeal.
Okay, good. That's good because they are awful.
Okay, Ms. Cohn, keep us
I guess
posted.
that's
Thank you
it.
for calling
I
in
will.
and sharing your story.
I
Let us
will.
know.
And I texted you, Miss G. I texted you a couple weeks ago. I don't know if you got it or not.
Wait, are you using the old number? If you're using the 462 number, I completely canceled that number. So I only
okay.
626 number. So anybody that texts me in the old 310 number, 462 number, no longer have it. But you can
Okay.
text me at 626-631-8901. Okay.
Okay. Okay. I'm gonna have to have I guess Gracie
Yeah, please.
text that to me because like I don't have none to write with right now.
It's right here,
So.
baby. It's underneath my chin, or
Okay, I see it. I see
right
it.
underneath. It
Okay.
shows you the number, so you can look at the show afterwards, and you can look at the number, and then that's my direct number.
Okay. All right. Great. Thank
You
you.
can call and text.
Okay.
You're very welcome, Cheryl. It's good seeing you
I'll,
again.
you too. I'll let y'all know what happens.
All right,
Thank you.
Cheryl. Good night.
All right. Bye bye.
Bye-bye.
I do remember her being on the show.
She was. I made a mistake on her name, but I do that with everybody. But yeah, I remember the face though.
Anything that you want to talk about this evening, Mr. Guai?
Just going back to that the service plan agreement thing. You hear a lot that people are threatened by the whole fact that if they don't sign this, they're going to take their kids. We all know that that's not correct. I mean, it just furthers the process. But what say you, Mr. Davis, on that topic?
Well, it's very difficult because it's one of those things that you don't know about the case. It's on a case by case basis, right? There's cases that you have that people should never take a deal. There's cases that you have that they should take a deal. And, I've gone both ways, and I've gone, once the case starts, sometimes I change my mind, for a trial or against a trial. It just depends. Depends on, the things that come out, the evidence that comes out. I'll give you an example. Um, Client hires me, tells me they don't use drugs on the first interview. So I go to court fighting, the drug test and
Right.
fighting, the client being labeled a drug addict and not able to take care of the child. And then sometimes, during the case, client tells me, oh, you know what, Mr. Davis, I do use meth, right? Or I've been a long time heroin user. So you just don't know. Do you guys remember a story that I told you about a client? A client and her father came, this is 20 years ago, comes to my office, and they claim that the social workers are treating them unfairly and won't return the child to the mother. And they're claiming that she has a heroin problem. Okay. And the client swears to me and to her dad that no way. I kicked that. I'm testing clean, blah, 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 blah. I made all my tests. So, of course, I get fired up. I'm going to go to court and, kick some butt. Well, I show up at the first court hearing for me. The case had been going on for a while. And one of the attorneys asks me, I think it was the county counsel, asked me, hey, Mr. Davis, what are you going to do with this case? And I, in a cocky attitude, said, I'm setting it for trial. Right?
Uh-huh.
So one of the other attorneys in the courtroom who wasn't on the case comes up to me and whispers to me. He says, "Vince, you need to read the report. They were talking about it before you got here." So, I take the report and I go sit in one of the attorney rooms in the back of the court, and I'm reading this report. And the report says, in many places, that the mother is still testing positive, like 8 out of the last 10 times. And I'm thinking, well, this can't be right.
Yeah.
The mother told me in front of her father, this can't be right. So I go out with the report in my hand, and I got to get to the bottom of this. My client is standing in the hallway with her father, with her mother, and other members of the family. And the woman realizes that I now know the truth. She walks away from the group, walks towards me, takes me by the shoulder, and leads me away from them down the hall. And she said, "Mr. Davis, I guess you read the report." "Yes, I did." "It's true, Mr. Davis. I haven't kicked the habit. I'm still using." I said, "But because you're my attorney, you can't tell anyone. You can't tell my father. You can't tell my relatives." Now, there's attorney-client privilege, and I can't tell anyone. So we call the case, and we don't set it for trial because obviously the evidence is all against her. She's admitting to me she's still testing positive. So we pick the continuation date. It's like 6 months away. We go outside, and she starts complaining to her family about me. Now, remember, she's already told me I can't disclose any confidences.
Right.
The case goes on. She actually loses the child, and her rights are terminated. Child's adopted. To this day, 25 years later, the family thinks I'm the worst attorney in the world because she continued the story that she didn't use drugs.
Mm-hmm.
So sometimes you can't set a case for trial.
Mm-hmm.
Right? Because your client says to you, "Oh, it's true." And as an attorney, you can't put a client on the stand if you know that client is going to lie. Clients told you I use drugs, but I'm going to get on the stand and say I don't use drugs.
Right.
I can't continue by law representing that client. And it happens occasionally, not a lot, but I've had clients get on the stand not knowing that they were not going to tell the truth, and somebody asked them a question, and they give an answer that I know is false. Do you know what the lawyer's supposed to do then?
Sure, stop everything, right?
Right. Stop the trial, take a break, approach the court, and tell the judge without telling her or him, "Hey, judge, I have a conflict. I can't continue representing the client." "Well, why, Mr. Davis?" "Can't tell you, Your Honor." There's going to be, one of the attorneys that's going to be on the seminar this weekend, and he was on last month, and his name is Arthur Lasalento.
Oh, nice.
Arthur Lasalento and I were doing a trial. He had the mom, and I had the dad. And at some point in the case, The judge orders La Salento to disclose a client confidence. Art refuses. The judge then brings in the presiding judge of the court, who orders La Salento to disclose the confidence. Art rightfully refuses. They order that he's held in contempt, but before they arrest him, they continue it 1 or 2 days so that he can file an emergency writ to the Court of Appeals. You know, he filed that writ and the Court of Appeals agreed with him. And both judges were kind of slapped on the hand. You know, so sometimes, you know, the court wants you to disclose a confidence. And on rare occasions over my, 30-some year career, that's happened to me, where a judge tries to get you to disclose a confidence that, you really can't disclose.
So does that hold like a level of HIPAA almost, the attorney-client privilege to, for the information you obtain?
It's stronger. It's stronger than that.
Stronger than that?
Yeah. So let's say I was representing you, Darren, and, you confess to me that you did rob the bank, right? I can't tell anybody that. And even if I did, they can't use it against you. There's the attorney-client privilege. And it's pretty sacred in the law, And it's it varies slightly from state to state, but in California, it's pretty strict. And I've had judges many times ask me, well, what is it, Mr. Davis? And I can't tell them.
Wow.
But anyway, getting back to the topic.
Back in the contract section.
Sometimes you can't do a trial.
Right. But if a person, the beginning of the day is CPS making you sign that contract, correct? Making you sign that safety plan. That's where the ball gets rolling, right? The money comes in, everything starts to happen. Is that the beginning of this whole, train track of devastation? Is the safety plan?
Pretty much the investigation that happens before the safety plan.
Right. So, because what I'm getting at is if there's errors in a safety plan, like someone's forced or they're said that, I'm getting at kind of like how you would defend that, I guess is what I'm trying to get to, is how would you defend if people are coerced, if they're told, look, if you don't sign this, we're taking your kids. An array of different things that people are told to sign these things because we know that they have money backed on whether they get people to sign them or they don't. And, all of these things. So what I know in the appeal, it wouldn't probably do you any good, but in your court trial and your original trial, if you were coerced or you were told that you weren't going to get your kids back, unless you sign this, do you have remedies for that?
Not in the CPS court. In criminal court, if they violate your constitutional rights, the case can be thrown out, dismissed.
Okay.
In CPS court, if they violate your civil rights, it's, too bad, so sad.
Right.
And we're here to protect the children. And if you want a remedy, you have to go across the street to the federal court and sue them for civil rights violations. And by the way, don't think that just because you sue them, you're going to get your kid back.
Right.
I have seen a case where the parent sued the social workers and the county and won. Won, I think, like $2 or $3 million. But guess what? She didn't get her kid back.
Yeah.
She went to family law court because that's the kid was placed with the father, and mother and father hated each other, and she still lost, even though she won the civil rights case. Now that's a real mind blower right there.
Well, that's just like you always explain the O.J. Simpson book,
Right. It's just like O.J. He gets found not guilty of killing 2 people, but They go across the street and they sue him for the same thing, same evidence, same witnesses, and he
Yep.
loses $40 million. Seems inconsistent, but that's the way our laws are written. Criminal court is different from CPS court, and they're not the same. And everybody expects them to be the same, and they're not.
Right. You always say that. You always say that just forget about everything you know about law when you go into CPS court because it's not going to be what you think it is. I mean,
Right.
that's just, it's unfortunate, but it's the truth. And what about appeals? What about when you take an appeal? I think a lot of people have discrepancies of what they think the appeal is about and what the appeal really is. So when you appeal your case, you get to do what to move forward in that process? Like what is being looked at? What's the overhaul of like what's going on in the appeal?
Generally speaking, in California, when you file a notice of appeal, the record is prepared, all of the transcripts, all of the reports, all the minute orders, and it's sent to the Court of Appeals. You file a brief arguing that the judge made a error in law or made a factual decision that's clearly not supported by any of the evidence. Now, if there was evidence and the judge chose to believe that over you, you're probably going to lose that issue on appeal. Because on appeal, they don't really review factual findings. Generally speaking, appeals are just on legal findings or on sufficiency of the evidence.
Right. So it's only surrounded by what was going on in that trial. When you went in that courtroom to that trial, you can only challenge what was said in that day, that moment's that, right? Or
Right.
if there was.
And here's the most important thing. At the appeal, you can't bring new evidence and new witnesses.
That's what I was trying to get at.
Yeah. So if you're going to prepare your case for an appeal, you better put all your witnesses in.
Right. Well, so I
all your
listened to
evidence in.
right. I hear so many times these people are like, oh, well, I'm going to, in my appeal, I'm going to have this and this and this. And I'm like, whoa, no, there's none of this.
Right.
You get to challenge whatever took place that day at that trial. And I mean, I don't know the extra things, but what I do know is that it's only because I've been through it and learned from you. There's only you get to check out what happened legally. You don't even get to question, other certain things. It's all just the legal status of the case, right? Of that trial, right? That's it.
That's correct.
Now, is there other remedies that you could challenge if let's say you missed your appeal? You're down in the dumps. You've done this. Is there any remedy that there is, or you've lost your appeal? Is there any sort of other challenge that you can throw back at the court?
You can ask for, in California at least, you can ask for a rehearing in bank, which means for more judges to get together and decide your case.
Okay.
Because in California, the first level appeal is only 3 justices, right?
Okay.
So you can say you can want an in-bank review if it's an important issue, and the judges all sit together as a division or as a court to decide, your case. That's a very rare event, but it can happen. Or you can appeal or file a writ to the California Supreme Court. And then if you lose there, theoretically, you can file a writ to the United States Supreme Court. It seems like every several years, I was going to say decade or so, you get a case out of CPS court in the United States Supreme Court. Yeah. So every once in a while, the justices in DC decide to take a case, and then they issue an opinion. There's one famous one. I forget the name of it, but it had to do with notice and due process. And the court ruled in favor of the parent. Said that what CPS did, violated the notice and due process provision of the Constitution. But those are, very few and far between cases, right?
Okay.
Anything else, Mr. Guay?
What about maybe? I'm sorry if we did this. We put the wagon in front of the horse. But what about being? Well, I don't know what they call it in California, but here in Maine we call it substantiation or substantiated. Um, Now I know, for instance, in a situation with my friend, he got noticed that he was substantiated. They came with a delivered overnight mail thing that he was given his substantiation notice in the mail. He hadn't been appointed an attorney yet. None of that stuff had happened. Um, and then afterwards, the ball started rolling where he got an attorney and so on and so forth. So he wasn't represented in the substantiation case. What do you have to say about the predetermination that you are guilty or they found some sort of evidence? What kind of rights do you have in those cases?
I'm not really following your question. I mean,
So
I
all right, so in Maine, they find you guilty to some degree of neglect and abuse before they actually start the investigation. Like if you if you break your safety plan or something like that, they find you guilty. They say you've been found guilty to some degree of neglect or abuse, and now we're going to move forward with you've been substantiated, is what they call it. And then they start forward with that. I don't know what they do. They have that out in California where they find you.
there's a little bit of a different version. Here, you have your initial hearing, the detention hearing, where they can keep the child away from you temporarily until you have the jurisdictional and dispositional hearing. The jurisdictional hearing is to determine whether anything you did was abuse or a risk of abuse to children. And then if they find that to be true, you go to the disposition hearing that says, even though they found you a risk to children, we can't keep your child away from you unless we prove by clear and convincing evidence that you are a substantial danger and no less restrictive alternatives. Now, that particular standard happens to be a constitutional standard. You can't take people's kids away from them for any length of time unless they have clear and convincing evidence. Now, there was a question earlier I saw, you know, they don't have to actually prove that you caused risk, you caused harm to the child. All they have to do is prove that you're a risk to take jurisdiction. But once they take jurisdiction, they have to prove that you're a substantial danger to keep the child away from you, because they could return the child to you and offer you services and look over your shoulder while the child lives to you. A lot of times I get the feeling that people argue preponderance of evidence and risk even at the dispositional stage, and that's not true. Well, it's only true if the child is placed with another parent. But if the child's in foster care and out of custody of both parents, you got to prove a substantial danger by clear and convincing evidence.
So if your child goes to anyone he doesn't, other than the parents, the preponderance goes out the window.
At the dispositional phase of the
Disposition
case.
phase. Okay.
Now think about this. How hard is it for somebody to prove that you are a substantial danger, not just a danger, a substantial danger by clear and convincing evidence? Do you realize you have to be one bad MF
Yeah.
to fall into
Correct.
that category? Right? Yeah.
Correct.
But people talk about it like, it means nothing.
Yeah. I mean, they make it that I hate to say it this way, but they're holding you, well, at least in this state, if you're to the highest degree of substantial abuse and neglect, you're held to the same degree of danger as a child molester or a pedophile.
Right.
I mean, that's pretty disgusting to even know that, because a parent had a few dishes in the sink that, you know what I mean? Like, they're putting you in that category. So this is kind of where I was getting at too. Are you supposed to be, I guess you don't know because you don't know how this goes. So I mean, this substantiation thing, they haven't even taken your kid yet. They've come, you've broken your safety plan because of some incident. So they've substantiated you, made you to the highest degree. Then they move forward. Should you be represented at that moment in that case? Should you, by the law or by rights, do you think?
Yes. Now, what's interesting, you bring that up, because I know another state kind of does it like you guys do in Maine, and they claim that they aren't given attorneys at that stage.
We're not either. We weren't either.
So I don't know if that's a way to save money or what, but you can get an attorney, but they just don't want to give you a free court-appointed attorney.
Right.
And I think that's the way they do it in Nevada. But my recommendation is, you should get an attorney at
Right.
every
Well, I
state.
mean, I could be wrong here, but I don't even believe that they served notice that you were going to be substantiated, that there was a hearing for you, because as I recall, firsthand, they reissued a safety plan the following day. The mailman was there with a overnight mail handed off to me personally, stating that, and I had no idea what this was even about. So I don't know. I'll look into that too in Maine. I was just curious because another friend of mine had just ran into the same type issue. And I'm like, this just something doesn't seem right. It seems like if they're finding you guilty to some sort of a degree of something, especially substantiating you,
You know
you would
what happens in a lot of cases, even outside of CPS law, is people realize that they have been breaking notice requirements forever. And then somebody says, well, wait a minute, I should have gotten notice. They file a lawsuit and they win. But it's been like that, for the last 5 decades,
right.
right? So, those issues are always important. And it sounds like, from what you're telling me, that they may be a due process problem. You might want to talk to a lawyer in Maine about
Yes.
that. That might be, I don't want to say an easy win, but that might be a
Right.
win, because if they don't give you notice, I mean, how are you going to protect yourself?
Right. Yeah.
Yeah.
That's how I had thought it too. But like I said, maybe it was overlooked. I'm not going to say for sure, because those whole moments are pretty chaotic.
Right.
Um, and especially not being used to being involved in the system. Some people don't pay attention to these things, and you're not sure. But as I would be 80%, I would say that it went down the way I said it did. So, and if that's happening in the state of Maine, then something, that's one of the things that I got to look for as a Maine team captain, to say, whoa, 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 like who's on board for figuring out how to change this rule or this law, because this isn't fair to substantiate people without them having representation, without them knowing that it's even happening, without them,
Right.
without all of these things. And, we're on the roll to the Capitol here with Mr. Davis. So, this is what I think the team captains should probably all start thinking too. Like, what rules are we lacking in this state, or what rules are non-existent, or what rules are happening that we're like, whoa, and putting a list down and start asking the, candidates or the whoever this election is about, finding out what's going on and how, they need to begin to inherently figure out how to change it.
Right. Hey, Miss G, we're moving towards the end of our program, and you're on mute.
Yeah. Sorry.
Miss G, this Saturday, we have the first Saturday seminar. And it's where we do an all-day seminar with about 5 or 6 different lawyers doing presentations for about 50 minutes, doing a 10-minute question and answer. And I'm proud to say that Double O, Corey Okoroka, has agreed. But a lot of other fine attorneys have agreed as well to do a presentation. Miss G, why don't you tell us the lineup we have for this Saturday? It's a pretty powerful lineup.
First of all, I would just like to let Virginia know that she's saying that she couldn't sign up for the seminar. You can text me at my my work number, Virginia, and you can and I'll send you a link to sign up for the seminar. So the lineup is 9 a.m. We're gonna have attorney Art Lasalanto, and at 10 a.m. we're gonna have Matthew Harris. He's from Texas, and at 11 we're gonna have Connie and Raguli, and at 1:10 p.m. we're gonna
Hold on. You're going through it too fast. let's go back. 9 a.m. is attorney Arthur J. Lasalento, the CPS attorney, one of the best CPS attorneys in Southern California. He's based in Orange County. I've known Art probably 25 years. And we occasionally do cases together against CPS. He's a former prosecutor in CPS cases. And then he left the dark side and found the light and started representing parents and relatives. He's highly experienced, highly trained in this CPS area of law. I know him personally, and I do cases with him. I was on a case with him today where he has mom and I have dad. He's at 9 o'clock. At 10 o'clock, we have attorney Matthew Harris. Matthew Harris is the Vince Davis of Texas. He's a young, aggressive attorney. He's very sharp, very polished, and he knows his stuff there in the state of Texas. He's at 10 o'clock. Then at 11 o'clock, we have the queen herself, the queen of CPS law, Miss Connie Ruguli. Oh,
Yes.
sorry, Connie, I always screw your name up. She's going to do another fantastic presentation. I wish you would have seen, or I hope you saw the presentation she did last month on the first Saturday. It was one of the best presentations I've ever seen. From 12 to 1, we're going to take a lunch break, and then we're going to come back. And at 1 o'clock, who do we have, Miss G?
Attorney Okari Akorocha.
Okay. So for those of you that didn't see the first seminar, or the show where Okori was on, Okori is a nationally recognized trial lawyer, both at the civil and criminal levels. But he decided to do something that I had never heard of. He went back to school and became a scientist. And his expertise is forensic testing of drugs. He can tell you what you should watch out for in terms of drug tests, drug screens, all of that type of stuff, and how to defend against a false positive. He spends most of his time now as an expert witness testifying for people regarding drug and alcohol testing. All right, so he's at 1 o'clock. The first three are great attorneys. The price of admission alone is worth coming to see Okori Okorocha.
Whew.
And he'll be doing a short presentation. We'll be asking him questions. We'll be taking questions from the seminar audience, and he will be hopefully answering those questions, helping you in your case. I think at the last seminar we did, he was able to tell someone what to do with respect to a false positive on their test. And, if you've had that or been accused of using drugs when you haven't used drugs, Corey is here to tell you how to prove that you're right. Okay, what's at 2 o'clock, Miss G?
Attorney Filler.
Attorney Filler, female attorney, right?
Correct.
Where is she from? California?
Mm-hmm.
Okay.
Yes.
Did you know what county she's from?
Long Beach.
Okay. So she's going to come on. She's going to tell us about practice in CPS cases in Los Angeles County. And who do we have at 3 o'clock, Ms. G?
Attorney Darcy.
And where's Attorney Darcy from?
California.
What area?
County.
Okay. We have Attorney Darcy. I don't personally know Attorney Darcy. Have you talked to that attorney?
No, but I talked to Attorney Filler. She referred her to me when I told her we need to fill another slot.
Okay, that's 3 o'clock. Who's at 4 o'clock, Miss G?
That's you.
Yes.
Oh.
And you know what? I copied Connie Reguli, and I have a kick-ass PowerPoint presentation. And it's on my favorite subject. My favorite subject, having been raised by my grandmother, is relative placement, getting kids placed with relatives. And I have to confess, I'm going last, um, but it may go over. My PowerPoint presentation is kind of long and it's involved, so it may take more than the 50 minutes. Hopefully, you will be there and you will stay tuned for that presentation. And hopefully, if you haven't, or if you decide to sign up for the seminar, you may want to sign up for the option that gives you a tape of the seminar, that a recording, so that you can have it and watch it as many times as you want. Okay? All
Is
right,
that
Miss
the
G. Go ahead.
is that the theme for the day? Is the relative placement, or is that just
No,
for your? That's just for
that's just
your
mine.
presentation.
So
Okay.
we have 6 or 7 attorneys presenting. Everyone has a different topic. We'll be talking about different things within the CPS court system, within the
Yep.
CPS court case. So it won't all be the same. And what's good is a lot of these people are from different eras in time, right? And a lot of them are from different states. So we get different perspectives for everyone, and hopefully everyone will learn some type of strategy that they can implement in their case or in the case of someone they know, family friend or a family relative.
That's
Okay?
great that we get you this time, because you were the presenter last time, so you didn't get a lot of Vince Davis knowledge in that last one. So this one's definitely going to be worth the buck for sure. Get a little
And
VD 50 plus.
and the mistress of ceremonies will be Miss G herself. So she will be riding the horse for Saturday. Okay, unless we have any more questions or comments, we're over as usual. You can never get that time thing straightened out. So we'll be on tomorrow. Tomorrow's Thursday at
I guess I'm
7.
not going to ask my questions then. Okay.
Oh, did you have questions, Miss G?
Apparently, I've been waiting.
Okay, go. Well, Mr. Bly, please
Yeah,
excuse us. Miss
I'm in.
G, go for it.
We're running out of time, right? So I'm not going to have time to ask you all the
Well,
questions.
hold on. You know what? The great thing about this particular app, StreamYard, where we do our live streams, is we can go forever.
Right.
Well, I think there's an 8-hour limit now that you mention it, but you probably don't have more than 30, 40 minutes of questioning. So let's do it.
Most of the people know that filing a motion is a way of asking the court to do something or not do something. Um, um, so what can you help people with the different types of motion, like motion for the grandmother to see to have placement of the children, motion, give them ideas of what type of different motions they can file in dependency court.
Well, that's a kind of a loaded question, Miss G, because the types of motions vary. There's so many different types depending on what you're trying to do. There's a motion you can file right at the beginning of a case. It's akin to a demurrer to challenge the sufficiency of the petition filed against you. And in California, there's a case called In Re Troy D. You can Google that, Troyd. And so that's one of the first motions. You can file a motion if you can't get discovery under the California rules of court. You can file a motion in limine to exclude certain types of evidence. You can file a motion, a 388 petition, which I call a motion, to change a court order. You can file a motion for de facto standing. You can file a motion for presumed parent standing. You can file a motion for a bonding study if you need that at the time of the termination hearing. So there's motions that you can make. A lot of times, and a lot of judges allow you to make these motions orally. And if they want it in writing, they'll tell you, I'm not going to make a decision. Give me some points and authorities, some legal authorities about it, and then we'll read that and we'll make a decision.
We both know that the probate court versus probate court and juvenile court same thing as CPS court. They both handle custody cases. Now, can you explain to the people the difference between the probate court versus juvenile court?
In California, probate courts are only dealing with custody if somebody files a petition for legal guardianship or conservatorship over a person. And in terms of minors, they could be a minor person or an adult. Typically, what you see in probate court is CPS is not involved in the case, but grandma needs to take custody of the kid because mom is, maybe out on the street using drugs. So grandma can go to court and get guardianship over the kid. Interestingly enough, grandma can't go to family law court to get custody, right? So she has to go to probate court. CPS court is something a lot different. That's when the county believes here in California or your state that the child has been abused or is in danger of being abused. And therefore they get involved and they, in most cases, take custody of the children and place them with relatives or foster care. I had a case the other day where the kids are placed with the parents, but yet there's a CPS case. Almost seems kind of ridiculous. They're saying that the parents are in danger of abusing the child, but the social workers agreed to leave the child with the parents. So I hope that answers your question.
Thank you. That's it. That's all I got.
Okay, very good. We didn't need those 8 hours.
No.
All right, Mr. Guai and Ms. G, I will see both of you tomorrow evening at 7 o'clock Pacific Standard Time. Everyone, take a look at the ticker. Sign up for the seminar on September 2nd. And let me give you a word of advice. Buy the ticket that allows you to have a tape of the program, because you're going to want to look at it over and over and over. And that way you don't have to worry about taking notes. You can just listen. Listening is so important. So think about doing that on Saturday or for Saturday.
Virginia, the number is the one. It was underneath my face, but I guess Davis removed it.
No. Hold on. It disappeared when you put Virginia's number up there. Now,
no. The number underneath
take Virginia's comment off and see what happens.
Oh, okay.
Oh,
So
yeah.
Virginia is
Virginia Davis didn't do anything. It was Miss G who did it, unknowingly taking over the show. But go ahead.
So it's the 626-631-8901 number that's underneath my chin. That's the one you need to text me at, Virginia. And then I'll be happy to send you the link.
Okay, folks. Good night. We'll see you tomorrow, 7 p.m. Pacific Standard Time. Good night.